Ms. Sylvia Lim, not here. Mr. Vikram Nair.
Chairman, access to justice is an important issue, and in recent times, the Ministry of Law and the Singapore courts have taken important steps to make sure those who need access to the legal system are able to get it. This includes making proceedings easier for the self-represented, the expansion of legal aid by easing the means test, and providing funding for some criminal legal aid cases too. It is also considering a fully funded public defender's office. These are important developments which I support. Over the last year, the Ministry also permitted the use of third-party funding and conditional fee arrangements for arbitrations, as well as for proceedings in the Singapore International Commercial Courts. This is a helpful development that levels the playing field somewhat between local and international firms. However, one area where I still believe more can be done is the area of domestic litigation for those who do not qualify for legal aid, but who may still lack the resources for an expensive, long-drawn suit, even if they have a valid claim. In these types of situations, I have two suggestions. The first is we can consider permitting conditional fee arrangements for these situations as well, meaning that lawyers can have outcome-based payments rather than having to collect payments based on rather than collecting fixed payments. The other is to allow damages-based awards. This means they can collect a proportion of any damages recovered. The country with the most liberal system in relation to the above is probably the US, and despite the potentially high legal costs there, access to justice is rarely a complaint by civil litigants because if a person has a good case, it is usually possible to find a lawyer to take it up and share the risk. The UK as well now allows both, although it circumscribes limits to the proportion of damages that can be claimed in certain situations. The main concern cited against this is the risk of frivolous lawsuits and that the advocate, by taking an interest in litigation, may not be able to perform his duty as an officer of the court. On the risk of frivolous lawsuits, I think this is unlikely to be high because lawyers will be bearing part of the risk, and it will be a big investment for them as well. In relation to lawyers acting as professionals, I think this risk can be managed, and other countries like the US and the UK are able to function with this. Next cut. Singapore is a melting pot, and our legal system currently provides a robust and clear framework for foreign judgments to be enforced here. One area, though, where this is not so easily enforceable is in the case of matrimonial law. And we are also a melting pot for mixed marriages, where I think 40% of Singaporeans, 25% of Singaporeans marry spouses of a different nationality, and we have lots of foreign marriages. However, it is not automatically easy to enforce custody orders or maintenance orders from a foreign court. These have to still be enforced under first principles through the Guardianship of Infants Act. So I would be grateful the Ministry could consider making it easier to enforce maintenance and custody orders from foreign courts, especially if divorce proceedings are determined there.